Welcome to the deep dive.
Mm,
Now, if you use public transit, you spend a lot of time on train platforms. They seem like places of routine, of order, right?
very orderly.
But our source material today, it really pulls back the curtain on some pretty massive overlooked risks hiding right there in plain sight.
Absolutely.
We're focusing today on accidents, specifically falls that happen in these public spaces, particularly in Aurora and the wider Denver area.
And this isn't just some, abstract safety talk. We're really getting into concrete accountability here.
Okay.
When you step onto that platform, the transit agency, the railroad company, they take on a huge legal responsibility. It's
A
serious.
responsibility for safety.
Exactly. And when a simple misstep happens, maybe because of a cracked tile or, poor lighting, it can lead to really catastrophic outcomes. We're talking severe fractures, head injuries, even spinal trauma.
Wow.
So yeah, we're here to unpack the legal side of things. Who pays the price when that basic responsibility gets ignored?
So our mission, really, is to dig into this source material and figure out that line. The line between just an unfortunate accident and actual negligence, especially, like you said, focusing on the challenges here in Colorado dealing with our public transport system. We want to move beyond just definitions and get into, well, strategy for the listener. Okay, let's unpack this.
Legit.
So the foundation first, liability. How does a huge entity like a railroad company end up being legally on the hook for someone falling on a public platform?
Well, liability simply means legal responsibility.
Yeah.
Pretty straightforward in concept.
Okay.
Transportation services, public or private, they're held to what's called a standard of care. It's a legal requirement, basically, to keep transit areas safe for passengers.
So platforms, stairs.
Platforms, stairs, railings, lighting, signs, you name it. Think of it like a contract almost. They have to maintain these areas. And if they don't, well, that's a breach of their duty.
Okay, but just having that duty isn't enough for someone who got hurt to actually, win a claim, is it? You have to prove they were negligent.
Correct. And that's the key.
Our sources really zero in on this critical idea. Constructive knowledge. Can you break that down? And maybe more importantly, how does someone actually prove it?
Right. Constructive knowledge. This is often where these cases turn. See, the difference between just, a random accident and a successful negligence claim, it really hinges on proving knowledge.
Knowledge that the hazard existed.
Exactly. Now, actual knowledge is kind of rare. That means proving the company definitely, positively knew about that specific broken tile or that burnt out light bulb.
Hard to prove.
Very hard. But constructive knowledge is, let's say, more common and definitely more strategic in a legal sense.
Yeah.
It means the company should have known about the problem
Should have known. How does that work?
because they have a duty to inspect their property regularly. They're supposed to be looking for hazards. So if a dangerous condition existed long enough that a reasonable inspection schedule would have caught it, then legally, they're considered to have known they had constructive knowledge.
Okay, so strategically, how do you actually demonstrate that CSTOT should have known? It sounds a bit like guesswork.
Oh, it's not guesswork at all. You prove it by challenging their diligence, their processes. The source material really emphasizes looking at things like maintenance logs.
Ah, the paper trail.
Exactly. Internal work orders, even prior customer complaints about that area. If those logs show, say, a recurring issue with cracked pavement in that spot, or maybe the company's own policy says inspect platforms every 72 hours, and oops, they missed the last few inspections for that location.
Then you've got them.
Then you've demonstrated constructive knowledge. It becomes a failure of their own system, their process, not just, failing to fix one specific crack they didn't know about.
That makes a lot of sense. That's powerful. Let's apply this right here to our region then. Denver, Aurora.
Duh.
We're often dealing with public agencies, aren't we? Like the RTD, the Regional Transportation District.
Yes,
And
absolutely.
dealing with a public entity like that, it comes with special rules, legal constraints, right?
It absolutely does. And this is, honestly, it's such a crucial point for anyone listening in this area. When you're going after a government entity in Colorado, and RTD falls under this stack, you're bound by something called the Colorado Governmental Immunity Act, or CGIA.
Governmental immunity.
That sounds tough.
It adds hurdles. And the biggest, most immediate difference compared to suing, say, a private company, it's the time limit. You absolutely cannot treat this like a typical injury claim you might file against a store or something.
Okay, you mentioned short deadlines. We had some feedback saying we need to be really specific here. What kind of deadlines are we talking about? Give us the actionable detail. Okay, absolutely critical detail here. For most injury claims against RTD or similar municipal agencies in Colorado, you have an incredibly short window. Typically, it's 180 days from the date you were injured.
180 days, that's just 6 months.
Exactly. 6 months to file a formal written notice of claim. It's a specific legal document. If you miss that deadline, your case is essentially dead in the water before it even starts.
Wow, no exceptions.
Very, very few. It's a strict deadline. And that's precisely why taking immediate, really comprehensive action after a fall is so vital.
Okay, that urgency is clear. So we understand why they can be held responsible, the duty, the negligence, the knowledge part. Now let's look at what actually causes these injuries on platforms. What are those common specific maintenance issues our sources highlight?
Well, depressingly often, they're highly preventable things. Environmental factors are huge, naturally. Wet surfaces, from rain, snow, melting off boots, maybe even spilled drinks or, ironically, cleaning fluids sometimes.
Right, slips are common.
Very. Then you get into the actual structure being neglected. Broken or uneven pavement, loose tiles sticking up, big cracks. Things that create these sudden, totally unexpected trip hazards.
And what about the things designed to help, like handrails?
Yeah, the supporting infrastructure matters a lot. Poorly maintained handrails, maybe they're worn smooth, or sections are missing entirely, or they're just loose and wobbly. That's a huge factor, especially on stairs or ramps.
Makes sense.
And lighting. Inadequate lighting, particularly after dusk or before dawn, it just hides all these other hazards perfectly. You can't avoid what you can't see.
And you mentioned something specific to the trains themselves.
Yes, the platform train interface, they call it. Unexpected gaps, either in height or distance, between the platform edge and the train car door. That catches people off guard all the time, especially if the train doesn't stop exactly where it's supposed to.
So let's really picture the result of that neglect. Someone's maybe rushing a little, glancing at their phone, trips on a tile section that, let's say, RTD was supposed to fix last month according to their own logs.
That one failure, that lapse in diligence, it leads to devastating consequences, doesn't it?
It really does. We sometimes focus on the small maintenance issue, the cracked tile, but the injury that results can completely alter someone's life.
What kind of injuries are typical?
The sources list a whole range of really serious harm. Complex bone fractures needing multiple surgeries, severe concussions that can cause long-term cognitive problems like memory issues or trouble concentrating, and really serious back or spinal trauma is unfortunately common too.
Beyond the physical pain, there's the financial side, the stress.
Oh, absolutely. Medical bills pile up incredibly fast. Then there's lost income from being unable to work, sometimes permanently, and the anxiety, the emotional toll, it's immense.
Okay, here's a tough question. Can it ever be argued, maybe by the transit agency's lawyers, that some of that financial strain, the lost work, is kind of self-inflicted if the victim waits too long to get legal help, especially with those tight RTD deadlines you mentioned? Oh, that argument is used all the time by defense teams, particularly if someone tries to handle it themselves at first.
Really?
Yes. If you blow past that 180-day notice deadline, well, you've essentially disqualified yourself financially right there. Game over. But even before that, if you delay getting medical treatment, the defense will jump on that.
How so?
They'll argue, well, maybe the injury wasn't that bad initially, or maybe something else happened between the fall and when you finally saw a doctor that made it worse. Their entire goal is to minimize their client's responsibility and payout, and they absolutely use any delay against the injured person.
Okay, that completely shifts the focus, doesn't it? It makes the immediate aftermath absolutely critical. If someone falls, shock sets in, obviously. But what they do in that first hour seems way more important than maybe the next 2 months.
Arguably, yes. Those first steps are crucial.
So we need that actionable checklist for our listeners. What are the absolute must-dos right after a fall on a platform?
Okay, 6 critical steps, according to our sources. Number 1, and this is paramount, get medical attention immediately. Go to urgent care, the ER, your doctor, whatever.
Even if it feels minor.
Especially if it feels minor. Some serious injuries like concussions or soft tissue tears don't always show severe symptoms right away. Getting checked out creates that undeniable time-stamped medical record linking the injury directly to the time and place of the fall. It shuts down that maybe something else caused it later argument.
Okay, vital. Step 2.
Report the fall officially. Find station staff, security, someone in charge. And you have to demand they file an official incident report. Don't just let them say, okay, we'll make a note. Get a copy if you can, or at least a report number.
Got it. Official report. Step 3.
Document the scene. Your phone is your best friend here. Take photos, take videos, get shots of the specific hazard, the crack, the wet spot, the broken railing, the poor lighting. Capture it from different angles, maybe put something next to it for scale, like your foot or keys.
Why so important?
Because that hazard might get cleaned up or repaired very quickly after you report it. You need proof it existed right when you fell.
Good point.
Okay, step 4.
Witness information. If anyone saw you fall or saw the hazardous condition, get their names and phone numbers or email addresses. Their independent account backs up your story and confirms the hazard was there.
Makes sense. Step 5.
This one's maybe overlooked sometimes, but our sources say it's strategically vital. Preserve evidence, specifically your shoes and clothing you were wearing when you fell.
Preserve your shoes. Why?
It's not just about, having general evidence. It's specifically designed to counter a very common defense tactic. They will try to argue that your fall was your fault because your shoes were inappropriate or the soles were worn out or whatever.
Blaming the victim's footwear.
Exactly. By preserving the shoes you were actually wearing in the condition they were in right after the fall, you can effectively neutralize that argument. It helps isolate the platform's condition as the real cause of the slip or trip. That's a really smart distinction, isolating the platform condition. Okay, I like that. And the last step.
Step 6. Write everything down as soon as you possibly can, while it's fresh.
What kind of details?
Everything you remember. The exact time, the date, the weather conditions, what you're doing right before the fall, how the fall happened, what part of your body hit the ground, how you felt immediately after, who you spoke to, everything. Memory fades fast, especially after trauma, and that detailed, immediate narrative becomes the backbone of your claim later on.
Okay, 6 steps. Let me ask this. If someone is down, hurt, dazed, maybe they can only manage one of those things right then and there. Which single step do the sources suggest is the absolute most vital, the one you cannot skip?
Ooh, tough call, because medical is critical for health. But purely for the claim, probably securing that official incident report, step 2.
Why that one above others?
Because while medical records prove the injury, the incident report creates the official record, linking the event to the transit agency's property and time. It formally puts them on notice, right then and there. It forces their system to acknowledge the incident happened on their watch. It's harder for them to later claim they knew nothing about it.
Locks it down. Got it. Okay, shifting gears slightly. While knowing your rights after a fall is crucial, obviously avoiding the injury in the first place is the goal. Right?
Always the primary goal, yes.
So beyond the company's responsibility, what practical tips do our sources offer for passengers to stay safer on these platforms? Proactive safety.
It really boils down to simple vigilance, honestly. Be hyper-aware of the weather. Assume surfaces are slick if it's wet or icy out.
Common sense, but easy to forget when rushing.
Exactly. Assume lighting might be poor, especially at night or early morning. Use your phone's flashlight to quickly scan the ground in front of you if an area looks dim. Notice weird areas, construction zones, even temporary ones. Fenced-off corners give them a wide berth. Hold handrails on stairs and ramps. Always.
And the big one.
The big one the sources emphasize. Don't rush for the train. Seriously. Running on a platform, especially when it's crowded or you're juggling bags, is statistically just asking for trouble. It's probably the #1 preventable cause of falls that people have control over. Missing one train is better than months of recovery.
Sound advice. But okay, let's say someone does take precautions, but the hazard is there, the duty of care was ignored, and they get hurt. You mentioned dealing with RTD, government immunity, those deadlines. Dealing with their big legal teams or massive insurance carriers alone sounds, well, daunting.
It is daunting,
Yeah.
especially when you're injured, stressed, and facing that ticking 180-day clock for the notice of claim. This is where getting legal guidance becomes really critical.
How specifically does a lawyer help in this type of case?
Several ways. First, they understand the very specific, complex rules of the Colorado Governmental Immunity Act. They know exactly how the notice of claim needs to be written and filed to be valid. That alone is huge.
Avoiding fatal errors right at the start.
Precisely. Second, they know how to properly analyze the evidence, those maintenance logs we talked about, your photos, witness statements, to build the strongest possible case for negligence and constructive knowledge. Third, they handle all the communication and negotiation with RTD's lawyers or their insurance adjusters who are trained to minimize payouts.
And what if the agency claims evidence is lost, like surveillance video or inspection records?
That happens. Experienced lawyers know the legal procedures to compel them to produce that evidence through formal requests, subpoenas if necessary. They know how to fight against claims of lost evidence, which sometimes miraculously appears when legally pressured.
Right. Okay, so wrapping this up, what does this all mean for our listener navigating the transit system here?
It means that the responsibility for keeping train platforms in Aurora and Denver safe isn't just a suggestion, it's a serious legal requirement,
Non-negotiable.
non-negotiable. And when that duty is breached, injured passengers have clear rights. But, and this is the crucial but, accessing those rights, especially against public agencies like RTD, is a race against the clock and requires proving specific things. The fight often isn't just about whether a hazard existed. It's about proving the system, the company, either knew about it or absolutely should have known it was there.
And that focus, that strategic angle on knowledge, actual or constructive, that seems to be the real key takeaway, doesn't it? The law spells out the responsibility, but making a successful claim really hinges on demonstrating that systemic failure, that lapse in diligence.
Exactly right. You have to think about the ripple effects. That one cracked tile that maybe seemed minor that got ignored during an inspection or put off for repair, that small lapse can cascade into a lifetime of pain, medical debt, and financial hardship for an unlucky passenger.
So, maybe a final thought for everyone listening. As you're out there using the rail system today or tomorrow, try to be a bit more vigilant. Notice those potential maintenance issues, the loose railing, the flickering light, the uneven pavement. Your awareness doesn't just protect you. Noticing and maybe even reporting those things provides data, evidence that the system needs better monitoring, better upkeep. It's about collective safety, too.
Well said.
Thank you for joining us for this deep dive into public transit liability and safety.